large number of relationships in the society. All need not be recognized. As a matter of fact, my lord, this is something very, very crucial, and regulation followed. So, my lord, the point is that there is no obligation for the state to recognize each and every social relationship.
The definition of transgender in this act covers the entire spectrum.
That's all I'm saying. I'm not, my lord.
But covers the entire spectrum of.
Then Article 14 argument, my lord, while challenging the Special Marriage Act, they say the Special Marriage Act is violative of Article 14, to which I say, Article 14 applies when government has created a mechanism for different classes, though they are same, or vice versa, which is not the case here. Or act has no nexus with the object it seeks to achieve. These are the two ground, my lord, for Article 14, my lord. We may call it arbitrariness, we may call it by any other name, but broad categories are this. My lord, here the Special Marriage Act is only for heterosexuals. And that's what, my lord, the debate also clearly show, and the language and architecture also clearly show.
Yes.
And the object is intra-faith and interfaith, intercaste marriage. And it seeks to achieve that, my lord, and there is no provision contrary to that. So, when you want recognition of a particular class of people in a particular class of relationship, it cannot be said that the other class legislation is violative of Article 14. Well, that's the submission. Now, petitioner wants a new class to be created. I have already made submissions for an entirely new object, which was never conceived at the time of, my lord, enactment. Now, my lord, there is no positive obligation on the state to recognize every social or personal relationship. There are a large number of relationships in the society. All need not be recognized. As a matter of fact, my lord, this is something very, very crucial. The state should be very slow in recognizing the relationship, because state is entering into the arena of socio-personal relationships. It can recognize only when it finds that legitimate state interest requires regulating them. And you can regulate only if you recognize them. So marriage also in heterosexual, ideally, should not have been regulated. But the society felt that you can't permit people to marry at any age. You can't permit people to marry as many times as they want. You can't people to stay together for 10 years and without reason part ways.
Yes.
You can't stay together for 10 years and part ways. And therefore, marriage was recognized with a clear legislative policy that it would be heterosexual, and regulation followed. So, my lord, the point is that there is no obligation for the state to recognize each and every social relationship.
Yes.
Then, choice of a sexual partner is a fundamental right. Right to get legal recognition of such partnership is not a fundamental. Then there is an intelligible differential between heterosexual and homosexual persons, as constituent units in both the classes are different. Heterosexual, my lord, has constituent units which are, my lord, of opposite sex, and homosexuals as a separate class has a different constituent. So it's not, my lord, that unequals are treated equally or equals are treated unequally. That's not the position. My lord, for example, zinc and brass both can be metals. No one is inferior, no one is superior. But they are treated separately. That's as simple as that. Then Article 14, 15 and 21 can be invoked only if law imposes prohibition on homosexual couples in their freedom of choosing sexual orientation and exercising their right in privacy, and not on heterosexual couples. If they say that heterosexual couples are permitted and we are prohibited, then, my lord, possibly 14, 15, 21 may come into play. Now, classification is based upon the nature of relationship and not on the basis of sexual orientation of individuals. Both, my lord, in Hindu Marriage Act as well as in the Special Marriage Act, the pith and substance is the nature of relationship, not your sexual orientation. And therefore, I say Article 14 prohibits class legislation and not classification per se. What we have done, what the legislature has done is classification which has intelligible differentia. Both are, my lord, different. Then Transgender Persons Protection Act provides for an affirmative classification in favor of one class mentioned in section 2K to protect Article 14, 15, 19 and 21 rights of all categories of LGBTQIA plus persons. Lord, if I show your lordships broadly the scheme of this act, Lord, first of all, transgender, the way in which we understand in colloquial parlance, which is equivalent to eunuch, general, that's not the way it is defined. Lord, for a second, if your lordships can just have a act, my lord. It covers all spectrums and shades, which, my lord, I have described yesterday, 2K. Does your lordship get 2K? Please see, my lord, widely worded, and I'll just read, my lord, the headings of the section. Transgender person means a person whose gender does not match with the gender assigned to that person at birth. This is the conventional, traditional understanding.
This is the first part, and then the second part is the inclusive part.
Yes, my lord. And includes, it widens the scope, trans man or trans woman, within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy or such other therapy. Natural as well as artificial, both. Person with intersex variations. Gender queer and person having such socio-cultural identities as Kinnar, Hijras, that is again, Lord, the conventional understanding of the term transgender. In between, my lord, every other spectrum is created, and Lord, gender queer and person with intersex variations include all categories. And just have a look at, my lord, prohibition against discrimination.
But, Mr. Solicitor, everybody who is an L or a G, the lesbian or the gay community, they're not transgenders.
They would be gender queer.
No.
Lord,
No, Mr. Solicitor. Somebody who is gay is not a person whose gender varies from what is assigned at birth.
Yes.
Their gender is exactly what is assigned at birth.
He is a man, my lord.
Born a man and continues to be a man. Born a woman and continues to be a woman. So they're not transgenders, therefore.
Lord, even bisexuals are not.
Undertaking can be given, we can give an undertaking with that effect.
क्या बोला, sir?
It's not correct, Mr. Solicitor.
What did Mr. Kripal say?
I am not disputing. I'm not disputing that. I'm not disputing.
Yeah.
Lord, L, G, B, then we are on T.
Right.
T is transgender. I say transgender, colloquially understood, is similar to, my lord, Kinnar or Hij. Anyway, don't get...
No, Mr. Solicitor, you may be right in this, that the definition of transgender in this act covers the entire spectrum.
That's all I'm saying. I'm not, my lord.
But covers the entire spectrum of transgenders. But yet, the community of gays and lesbians is completely distinct from the transgender population.
It does not cover the entire class.
Yeah,
I mean, if
exactly.
you put them all as one class, LGBT,
It's not an interchangeable.
they're not there.